Mr. Chief Justice, and may it please the Court, the intimate and committed relationships of same-sex couples, just like those of heterosexual couples, provide mutual support and are the foundation of family life in our society. Yet the legal commitment, responsibility, and protection that is marriage is off limits to gay people as a class. The stain of unworthiness that follows on individuals and families contravenes the basic constitutional commitment to equal dignity. Indeed, the abiding purpose of the 14th Amendment is to preclude relegating classes of persons to second-tier status.
What do you do with the Windsor case where the Court stressed the federal government's historic deference to states when it comes to matters of domestic relations?
States do have primacy over domestic relations, except that their laws must respect the constitutional rights of persons, and Windsor couldn't have been clearer about that. And here we have a whole class of people who are denied the equal right to be able to join in this very extensive government institution that provides protection for families.
Well, you say join in the institution. The argument on the other side is that they're seeking to redefine the institution. Every definition that I looked up prior to about a dozen years ago defined marriage as unity between a man and a woman as husband and wife. Obviously, if you succeed, that core definition will no longer be operable.
I hope not, Your Honor, because what we're really talking about here is a class of people who are, by state laws, excluded from being able to participate in this institution.
Mr. Chief Justice, and may it please the Court, the opportunity to marry is integral to human dignity. Excluding gay and lesbian couples from marriage demeans the dignity of these couples, it demeans their children, and it denies that both the couples and their children the stabilizing structure that marriage affords. Now, the respondent's principal argument and what we've been discussing this morning so far is whether this issue of whether this discrimination should persist is something that should be left to the political process or whether it should be something decided by the court. And I'd like to make 3 points about that if I could. First, I think it's important to understand that if this Court concludes that this issue should be left to the political process, what the Court will be saying is that the demeaning second-class status that gay and lesbian couples now inhabit in states that do not provide for marriage is consistent with the equal protection of the laws. That is not a wait and see. That is a validation. And second, to the extent the thought is that this can be left to the political process because this issue will take care of itself over time because attitudes are changing. What I respectfully submit to the Court is that, although no one can see the future perfectly, of course, that it seems much more likely to me that the outcome that we're going to end up with is something that will approximate the nation as a house divided that we had with de jure racial segregation. You may have many states, perhaps most states, in which gay couples can live with equal dignity and status, but you will have a minority of states in which gay couples will be relegated to demeaning second-class status, and I don't know why we would want to repeat that history. And third,
General, I'm sorry, go ahead.
And third, I want to just expand on what Ms. BONAUTO said, and I think, Mr. Chief Justice, you did recognize this, that the decision to leave this to the political process is going to impose enormous costs that this Court thought were costs of constitutional stature in Windsor. Thousands and thousands of people are going to live out their lives and go to their deaths without their states ever recognizing the equal dignity of their relationships.
Well, you could have said the same thing 10 years ago or so when we had Lawrence. Haven't we learned a tremendous amount since Lawrence, just in the last 10 years?
Yes, and, Your Honor, I actually think that's quite a critical point that goes to the questions that Your Honor was asking earlier. I do think Lawrence was an important catalyst that has brought us to where we are today. And I think what Lawrence did was provide an assurance that gay and lesbian couples could live openly in society as free people and start families and raise families and participate fully in their communities without what the respondents are ultimately saying to the Court is that with respect to marriage, they're not ready yet. And yes, gay and lesbian couples can live openly in society, and yes, they can raise children. Yes, they can participate fully as members of their community. Marriage, though, not yet. Leave that to be worked out later. But the petitioners, these gay and lesbian couples are...
Or not.
I mean, that's not what they're saying. They're saying leave it to the people. It'll be worked out later or not.
But what these gay and lesbian couples are doing is laying claim to the promise of the 14th Amendment now.
Mr. Chief Justice, and may it please the Court, respondents are not saying we're not ready yet. Respondents are really echoing the questions that Justice Breyer was asking. This case isn't about how to define marriage. It's about who gets to decide that question. Is it the people acting through the democratic process, or is it the federal courts? Lawrence said the government cannot interfere in private, intimate conduct. Our position is that the court cannot, as a constitutional matter, say, but yes, you can force the state into these relationships by forcing them to recognize and give benefits to anyone. That's not the way that our fundamental rights doctrine works. So, Justice Kagan, to get back to your point again about how the Constitution does put limits, there haven't been any identifiable limits here that defeat the state's interest. You would have to somehow change one of those doctrines. You'd have to change your fundamental rights doctrine. You'd have to change equal protection doctrine. And when you change those, you also change the balance between the federal courts and the people voting in the democratic process.
See, to me, it seems as though you're doing something very different that we've never done before, which is you're defining constitutional rights in terms of the kinds of people that can exercise them. And I don't think we've really ever done that. Where we've seen a constitutional right, we have not defined it by these people can exercise it, but these people can't, especially in a case where the claims are both rights-based and equality-based. I mean, it would be like saying in Lawrence, well, there's only a right to intimate activity for heterosexual people and not a right to intimate sexual activity for gays and lesbians. And, of course, we didn't do that. Once we understood that there was a right to engage in intimate activity, it was a right for everybody.
Absolutely. But that's the state's whole point, is that we're not drawing distinctions based on the identity, the orientation, or the choices of anyone. The state has drawn lines, the way the government has always done, to solve a specific problem. It's not meant to exclude.
Well, it's
not meant to take away dignity.
That's why you're drawing distinctions based on sexual orientation.
Oh, gosh, no, because the state doesn't care about your sexual orientation. What the state cares about is that biological reality.
I'm not asking about your reasons and whether you have any or not, but whether you have any or not, you are drawing distinctions based on sexual orientation. That's what these laws do.
No. A statute that facially classified based on sexual orientation would look very different.